let's get to what are the first steps that are taken before the arbitral tribunal and what is it that one could expect from the arbitral tribunal when you first go to them. So the first thing that happens is once the tribunal is constituted and the parties have issued their notices to the other side and they've appointed arbitrators and the tribunal is constituted, then a disclosure is sought from the arbitrator under section 12(1)(b) of the Arbitration Act. This disclosure is essentially a statement where the arbitrator says that he is competent to act in this particular matter and that he has no dealings with the parties in any way which would cause any sort of bias. The essential point of this disclosure is to show that there would be no bias caused by the appointment of a certain person as arbitrator. What next happens? The next step is that a preliminary meeting is called for by the arbitrator. The arbitrator will write to both parties, or maybe to the claimant usually, saying that I am fixing XYZ date to hold a preliminary meeting to fix the timelines, costs, schedules, etc. for the arbitration proceedings. The claimant would then typically inform the advocates for the respondent and they would convene to meet at a particular venue to hold this preliminary meeting. Now, it is important from a practical standpoint to understand that the claimant and the claimant's advocates are always in carriage of proceedings. Now, being in carriage of proceedings means that all the logistical arrangements that have to be made, etc., all of that will be done by the lawyers for the claimant. Of course, in consultation with the advocates for the respondent, but the primary responsibility of arranging the venue, the transport for the arbitrators, things like specialized stationery, even some things like laptops, etc. sometimes, all of that rests with the advocates for the claimant. The only thing that the advocates for the respondent have to do in this case is to pay the money and to show up for the proceedings. So in that sense, it actually is better to be an advocate for the respondent. All that sort of headache is not on you. It falls on the claimant's lawyers. So now, once the preliminary meeting is called, what actually happens at such a preliminary meeting? You will have both the parties present, of course, sometimes represented by their counsel, more or less represented by their counsel. The parties will, and the arbitrators will also be present at this hearing. The parties will just inform the arbitrators briefly about what the dispute at hand is, whether they are going to be filing any applications. By this I mean, a claimant may choose to inform the arbitrator that a potential Section 17 application is being filed for interim relief. As discussed while speaking about Section 9 petitions, Section 17 applications are no different. They are to seek interim relief. It could be again in the nature of securing the claim amount, preventing assets from being disposed, sale of any particular goods, etc. So that's what the claimant might do. Then the respondent might inform the arbitral tribunal that they have an issue with the jurisdiction of the tribunal itself. Now, under Section 16 of the Arbitration Act, the parties can raise disputes regarding jurisdiction of the arbitral tribunal, and under Section 16, the arbitral tribunal can rule on its own jurisdiction. So there are often times where you'll find that respondents, even though they've agreed to arbitrate in their reply to the notice invoking arbitration, they would have indicated somewhere there that that they do not have that they're not in agreement with the arbitral tribunal being constituted in terms of the agreement, but any which way they are going ahead with the arbitration because there is an arbitration agreement. Similar to this is when a court of law itself will, at a Section 11 stage or a Section 9 stage, have an order, at the bottom of the order, have a small noting which says that all issues between the parties are kept expressly open. And the reason for this is so that the parties may take out applications under 17 or 16 before the arbitral tribunal. So at this preliminary meeting, the claimant may inform the tribunal that they are filing a 17 and the respondent may inform the tribunal that they are filing a 16 to challenge the jurisdiction. After hearing the submissions, these very brief submissions that the parties may make, the tribunal then goes ahead and fixes the timelines for the various applications and processes of the entire arbitration. The first would be to say when the statement of claim is filed, when the statement of defense is filed, when the applications are filed, what is taken up for hearing before. Typically, if there is a section 16 application or there is a 17, that will be taken up for hearing before the actual commencement of the cross-examination, etc. Sometimes, after having a review of the applications that are filed by the parties, the tribunal actually feels that the contentions raised in the 16, not so much the 17, but the 16 more, they are so innately tied up with the merits of the case that they ultimately say that both the section 16 application and the entire process of arbitration, that's the evidence, etc., all of that will be heard together, and ultimately we will rule on jurisdiction in our final award. So it's not necessary that a section 16 application has to also be heard at the preliminary stage. Once the parties have informed the tribunal of any applications that they may file, the tribunal then fixes the schedule for the arbitration. You will have different stages that the tribunal records. All of these are recorded in the form of what is known as a procedural order. And since it is the first procedural order, it is usually called procedural order number 1. Procedural order number 1 sets the entire foundation for the arbitration proceedings to go ahead. This would also include the fees that are payable to the arbitral tribunal. So the fees payable to the arbitral tribunal in case of, say, ad hoc arbitrations where parties have appointed the arbitrator by themselves without the rules of an arbitral institution, that would actually be left to the discretion of the arbitrators to determine. If it is an institutional arbitration, the arbitral institution under which the arbitration is being conducted, that would actually have a set process of what the fees payable to each arbitrator is. So if it's a 3-member tribunal, each of the arbitrators will get a certain fee, with the presiding arbitrator drawing a higher amount than the 2 arbitrators who are the parties' respective arbitrators. So a side note for you to consider is that the fees payable to the arbitrators are not always determined by the parties, by the arbitrators themselves in an ad hoc proceeding or according to the rules of institution in case of institutional arbitrations. Sometimes when parties have approached a court of law for appointment of arbitrator, usually this is in the case of a sole arbitrator, the fees payable to that particular arbitrator will be as per the 4th schedule to the Arbitration Act. Now the 4th schedule lists various stages of the arbitration proceedings, and depending on what stage is achieved, the arbitrator is to be paid a certain amount of money. There is also a process where if the arbitrator completes the arbitration within a period of 6 months, he is actually to be given a bonus amount. Now, the fees payable to the arbitrator, this is something that is also recorded in the procedural order, and therefore what you will see in a procedural order are not only timelines for filing various applications, for conducting evidence, cross-examination, etc., but also what fees is payable to the arbitrator per sitting, for reading fees, etc., and when it is payable to the arbitrator.